Right. Are we live right now, Maksud sir?
Yes, ma'am.
Okay. So good afternoon, everyone. Welcome to Amity University, a research and innovation driven university. At Amity University, we follow the ideas laid down by our founder president, Dr. Ashok K. Chauhan. Amity University is a research and innovation driven university, and we take pride in saying that Amity University is the leading university in India and abroad in terms of research and innovation, and also in terms of how many foreign students come to study here and how many students go abroad in seeking education. Today, we are 12 universities in India with more than 12 international campuses with 28 schools and preschools, all following the ideals of our founder president, Dr. Ashok K. Chauhan sir. Today, this webinar is being hosted by Amity Law School, Noida, under the aegis of Amity Legal Aid and Literacy Committee. And the topic for today is something that is very, very close to the heart of every Indian because India is such a populous country. We believe that there should be, there are two words, quality and quantity. If the population is skilled, the country would rise. So, adoption is one of the ways in which many problems can be solved. So without any further ado, I will now request Maksud sir to play the Saraswati Vandana video so that we can take the blessings of the goddess and begin with the webinar. Over to you, Maksud sir. Maksud sir, can you play it again, sir?
Yes, ma'am.
शारदे माँ अज्ञानता से हमें तार दे माँ मुनियों ने समझी है गुणियों ने जानी वेदों की भाषा पुराणों की वाणी मुनियों ने समझी है गुणियों ने जानी वेदों की भाषा पुराणों की वाणी हम भी तो समझे हम भी तो जाने विद्या का हमको अधिकार दे माँ हे शारदे माँ हे शारदे माँ अज्ञानता से हमें तार दे माँ हे शारदे माँ हे शारदे माँ अज्ञानता से हमें तार दे माँ हे शारदे माँ हे शारदे माँ अज्ञानता से हमें तार दे माँ
Thank you so much, everyone, for participating in the virtual Saraswati Vandana. With this, we invoke the blessings of the goddess and let's immerse into the realm of knowledge, which will brighten all of us, and so that we can also spread knowledge across the globe. Well, everyone, today's topic is very close to our hearts, and also this topic is very emotional, and that is why we decided that we should go ahead with this topic. So, adoption of child in India or across the globe, I'll talk about my country, however. So, it is, It is a legal and emotional process which includes that you accept the responsibility of caring for a child who is not biologically related to the adoptive parents. So, the process of adoption in India is monitored and regulated by the Central Adoption Resource Authority, which is called CARA, which is a part of the Ministry of Women and Child Care. So, CARA is the nodal body for adoption of Indian children and is mandated to monitor and regulate in country adoptions. So, CARA is also designated as the central authority to deal with inter-country adoptions in accordance with the provisions in the Hague Convention on Inter-Country Adoption 1993, ratified by Government of India in the year 2003. Well, we have many eminent panelists who will talk upon this. However, I would like to talk a little about the laws which are related to adoption in India. Well, the adoptions in India are governed majorly by two laws. One, the Hindu Adoption and Maintenance Act of the year 1956 and the Juvenile Justice Act of the year 2015. So both the laws have their separate eligibility criteria for the adoptive parents. In a country like India, which has got the highest population in the world, how can the problems related with unemployment, related with a little and land area which is available for residents and other things, can that be solved by adoption? This is actually the main topic. What are the challenges in adopting the children, and do you think when you adopt a child, do you think we can solve the other problems of our country? So there are key changes which are there in the adoption laws in India. And without any further ado, let me just inform everyone. And well, with that, I welcome all the panelists who've joined us. Honorable Justice Rajesh Tandon, sir. Then we have with us Advocate Vidyot Majha. We have with us Dr. Nitin Sharma, sir. We have with us Advocate Amit Mehndi Ratta. Let me give you a brief profile of the first panelist who is with us. None other than Honorable Justice Rajesh Tandon, sir. Honorable Justice Rajesh Tandon, sir, is the former chairman, Uttarakhand State Law Commission, former judge, Uttarakhand High Court at Nainital, former chairperson, Cyber Appellate Tribunal, Government of India, former chairman, Admission and Fee Committee of Private Education Institutions in Uttarakhand, former vice chairman, Amity Institute of Cyber Law and Cybercrime Uttar Pradesh, former member, Human Rights Commission Uttarakhand, former member, Sanskrit University of Uttarakhand, and so much many more. Sir has also joined us as additional vice chairman, Amity Judicial Academy and Amity Law Foundation. So without any further ado, I'll now request Honorable Lordship Justice Rajesh Tandon, sir, to present his address.
Thank you. The Amity University, with the grace of our founder president, Dr. Ashok K. Chauhan, has adopted this topic of adoption. Now, this topic of adoption is really a great topic. Dr. Sumitra Singh and all the panelists who are present here has I myself thankful to Sumitra Singh and all that panelists who have joined here for this topic. The Hindu Adoption and Maintenance Act 1956 was an outcome of after the freedom of 1947 and also of adoption of our constitution on 26th of November 1950. The first step at that time the government has taken to legalize the adoption and also to legalize the maintenance of the wife. This adoption, Hindu Adoption and Maintenance Act, was passed on 21st of December 1956, and which provided that any person who is Hindu by religion and including a Vaishno, linguist, or any person, Brahmin, he may adopt this child. Now, it is really a contribution to the Hindus, and Hindus can always proceed for adoption under the Hindu Adoption and Maintenance Act. Now, any child, the main contribution of the government is that any child legitimate or illegitimate. That is legitimate or illegitimate. That is the main crux of the government, that the illegitimate children who are there may not be think that they are just have not are being neglected, or they are also being no one to care them, and therefore the adoption theory of adoption applies to legitimate or illegitimate both, and the parents can adopt the same child of legitimate or illegitimate, जिसके की parents Hindu, Buddhist, Jain, Sikh by religion are there, they may adopt the child. Now the main thing is that what is the criteria of the children to be adopted. Adoption is controlled by Section 5 of the adoption. The condition of the adoption is that the person adopting has the capacity and also has the right to take in adoption. Capacity means that any male Hindu who is sound mind and is not a minor and has the capacity to take the daughter in adoption. Now, provided that if he has a wife living, he shall not adopt except with the consent of his wife. Means his wife must have consented to it for the adoption of the daughter. A person who is a sound mind can adopt any daughter, provided he has taken his due consent with his wife. Therefore, under the Hindu Adoption Maintenance Act, the restriction has been placed that suppose a daughter has been adopted and his wife has not given consent to it, then he cannot adopt it. Then capacity of female Hindu to take in adoption, a female Hindu who is sound mind and is not a minor has the capacity to take a son or daughter in addition. That criteria for the male and also applies to the female. Now, female also can adopt a child provided she has a husband living, then she has to take consent from her husband. Therefore, in both the ways, if the woman adopts, then the husband consent should be there, and if the female adopts, then the consent of husband, both should be there, and that the act therefore has been adopted in order to minimize everything, that there should not be any quarrel in the family. Suppose a child is adopted by a man, his wife is not consenting to it, then it will be anarchy in the family also. And similarly, wife adopts, her husband does not consent to it, then anarchy will start in the family itself. These are the criteria, therefore, Hindu Adoption and Maintenance Act 1956, which has been maintained, it has been taken into consideration that there may not be any quarrel in the family, and the family may also live peacefully with that adopted child. That is the criteria, and therefore adoption will also result that he owns everything of the family. Therefore, the estate and all the properties will also will be bestowed by him on him. He can adopt anything after a proper adoption has taken place. Similarly, the Act also provides the maintenance of the wife. Nowadays, generally, marriage takes place and thereafter the cruelty starts and the wife has to take shelter from somewhere else. Then the maintenance of wife has also been given under the Hindu Adoption and Maintenance Act under Chapter 3, that is Section 18 to the maintenance of wife. There are also maintenance of wife is also be granted under Section 24 of the Hindu Marriage Act. That is another criteria. And she may also claim the maintenance under the Hindu Adoption and Maintenance Act. Here also, maintenance to the shelter has to be given by her husband, because if she has been given a go-by from house, then some shelter has to be provided by her husband. And unless she provides some shelter, she can't live anywhere. And all these criteria are that if if she has been deserted from the house, she has been deserted from the maintenance, she has been deserted in the house for shelter or all that, then it is the duty of the husband to provide a proper shelter to him, and also amount of maintenance shall be determined in order to claim a maintenance by the wife. Some of the judgments have also come by the Supreme Court of India, where the question of maintenance has come up, and the maintenance has also been decided. It was stated that so far as gainful employment of wife is concerned, the said issue is no more in controversy. The wife was held entitled to maintenance, and the said right has been upheld up to this court. Therefore, regarding medical expenses, the wife had also undergone 2 major operations, and still she is not completely cured. In future, she will have to undergo further operation and also to take medical treatment. She has spent substantial amount. The Supreme Court has held in these circumstances where the medical expenses are also required, where maintenance of the wife is also required, then the husband is entitled to maintain, and the maintenance also has been defined by the Supreme Court in so many cases, and also it has been held that the court is empowered to pass interim orders also. Suppose an application is filed, the court may also grant interim maintenance to the wife, apart from Hindu Marriage Act and all that, where Section 24, Section 28 and all that has been mentioned for permanent alimony and interim maintenance. This also provides, the Hindu Adoption and Maintenance Act also provides. That's a very smell again. Now, one more thing is regarding adoption. There is also Supreme Court judgment, and that provides the criteria that when adoption is validly done under the Hindu Adoption and Maintenance Act, then the consequence of natural guardianship passing to the adoptive father must follow, and in that event, it is not open to the authorities not to recognize. The question arose that the passport authorities have not recognized the adoptive guardian, and therefore the Supreme Court has to interfere in the matter in cases where there is a valid adoption under the Hindu Adoption and Maintenance Act. The passport authorities would not be justified in insisting on getting declaration of guardianship under the Guardianship and Wards Act, because the natural guardianship passes to the adoptive father and or mother, as the case may be, by virtue of the provisions of Section 12 of the Hindu Maintenance Act. Now, let us show before you the Section 12, which provides that thereafter, after the adoption, the criteria will be, the natural guardian will be of the adoptive father and mother. Effect of Section 12 provides effects of adoption. An adopted child shall be deemed to be the child of his or adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child in the family are worth shall be deemed to have severed and replaced by those created by the adoption in the adopted family. The child cannot marry any person whom he or his could not have married, such and such, and therefore the intention of the act is that now adoptive father, adoptive mother will be the natural guardian, and the old father, mother will go away, and only no certificate is required, nothing of the kind, and the presumption has been adopted in favor of the natural guardian. These are the facts, and therefore the act provides for the safeguarding of the children, legitimate or illegitimate, safeguarding of the wife who has been ousted from the house itself. These are the precautions which the government at that time has taken. That is on 21st of December 1956, when the act was adopted, and the preamble of the act was an act to amend and codify the law relating to adoptions and maintenance amongst Hindus, and therefore the wife or the ladies who are here, and the girls who have to marry, they must be alert that if she has been rejected from the wife, she has been not been given a proper food, lodging, shelter, and all these things will be provided by the court itself under the Hindu Adoption and Maintenance Act 1956. This is the crux of the matter. I take liberty to be out from here, and let me also go and serve my wife proper maintenance and proper food, proper lodging, and all that. Let it begin. Charity begins from home itself.
Thank you so much, Lordship. Such a wonderful perspective on the topic. Thank you so much for being here. Over to Shreya and Srijaya. Over to you.
Thank you so much, Rajesh Chandan sir. Hello and welcome to this webinar on adoption rights in India, challenges and opportunities in a populous nation. My name is Shreya, and me and Priyanshu will be the moderator for today's session. India is a country with a large and diverse population, but also with many social and economic issues that affect the lives of millions of children. According to the latest census data, there are 20 million orphans in India, but only about 50,000 of them are legally available for adoption. This means that there is a huge gap between the demand and supply of adoptive families, and also a lack of awareness and transparency in adoption process.
In this webinar, we will explore the current state of adoption rights in India, the challenges faced by prospective adoptive parents and children, and the opportunity for improving the situation. We have invited some experts, practitioners from this field of adoption to share their insights and experience with us. We hope that this webinar will be informative and engaging for you, and that you will learn something new and useful from it. Thank you for joining us today. Now I would like to invite Dr. Sumitra ma'am, our faculty in charge, to welcome the guest and share her views.
Yes, I warmly welcome all the panelists today. I welcome Honorable Justice Rajesh Tandon sir, Dr. Nitin Sharma sir, who's joined us from Jammu, and Dr. Vidyotma Jha, a wonderful speaker, a very dynamic advocate, leading attorney at Supreme Court of India, Mr. Amit Mendirata, who's also a leading advocate. So welcome all the panelists, and also we have got student panelists here. It's so good to see Srijaya. Then it's so good to see Shreya, Priyanshu, and also Isha, Aryan, all being a part of this webinar. So this is a topic to deliberate on the modalities of this particular law, and we all got to understand it because we, as an awareness committee in a law college, it is our duty to make the people aware about these laws. So thank you so much, Priyanshu. Over to you.
Thank you, ma'am, for sharing your valuable information insight. Now, I would like to call ALLC student Aryan to share his views on today's topic.
Good afternoon, ladies and gentlemen. I stand before you to discuss the imperative aspects of adoption rights from a legal perspective. Adoption laws shape the framework that governs the process, impacting not only the lives of adoptive parents, but more significantly, the well being of the children involved. As we know, legal recognition of adoption rights is paramount in the establishing a fair and inclusive society. It ensures that individuals and couples, irrespective of their background, can navigate the adoption process with clarity and equality. Legal frameworks must be designed to eliminate discriminatory barriers, fostering an environment where the best interest of the child take precedence over arbitrary restrictions. Moreover, adoption laws should adapt to evolving societal norms, recognizing and accommodating diverse family structures. By doing so, we create a legal landscape that reflects the changing dynamic of our communities and respects the rights of all prospective parents. In conclusion, advocating for robust adoption laws is a call for legal equity and social progress. Let us work together, legal frameworks that prioritize the welfare of children, uphold the principles of fairness, and embrace the diversity of families seeking to provide loving homes. Thank you.
Thank you, Aryan. Now we are going to display a video on ground reality of adoption in India.
Let's go, friends.
Hello everyone and welcome to my channel.
YouTube content creator Sahana successfully adopted a child in 2017, but the process was not simple or quick. After a 2-year wait, Sahana and her husband Rishu Kumar brought home their baby girl and grew their family.
Decided in 2016 June that when we wanted to adopt. So then when we searched on the net, we found CARA, that is Central Adoption Resource Authority. I understood, okay, now we have to register, so we had a very good opportunity to go and meet the counselors in person. So we could actually meet and, talk to them, clear all our doubts, all our perceptions.
Experts say that the adoption process takes time because of the checks and balances involved in ensuring the child finds a good, stable, and nurturing permanent home. But the COVID-19 pandemic and ensuing lockdowns threw a wrench in the process. Timelines widened to between 3 and 4 years. Pending adoption cases across various family courts have risen from 629 in July 2018 to over 900 cases as of September 2022. In an effort to speed up the process, the government amended the Juvenile Justice Act 2015. These changes allowed even district magistrate courts to hear and approve adoption applications and tried to shorten timelines.
The amendment have happened in 2021 and the adoption rules have been come out in 2022. There are cases pendency in the courts for almost like 2 years, 3 years. These new change, if we welcome with a positive note, it is definitely going to help us, because the stipulated time period that has been given is like within 60 days the case need to be disposed of.
But in reality, the change has been slow. Experts say adoption cases are often not accorded priority in district courts, where a district magistrate already has a full plate, being responsible for maintaining law and order, land and revenue administration, disaster management, general administration, and implementing government schemes and programs in their district. That's not good news for the 31 million Indian children that UNICEF says are orphans or have been abandoned, over 227,000 of whom live in childcare institutions. The COVID 19 pandemic is seen as a big contributor to this number, though estimates differ. A report by Lancet in February 2022 said 19 lakh Indian children have lost their primary caregivers due to COVID 19. The Ministry of Women and Child Development, however, says only 1.54 lakh such children have been registered with it. Of this number, 1.42 lakh children have a single parent, 492 were registered as abandoned, and 10,386 children have lost both parents. Experts fear many of these children, especially COVID orphans, may be at risk of falling through the cracks.
After COVID, we heard so many numbers of children getting orphaned due to COVID issues, and there are so many children who had no support, but very few have come up or turned into the institutional care. Of course, there are reasons because of the PM cares or the state level alumni that has been offered to them, but where this exactly where they are ending up, like are they into the safe nets? So these also need to be studied. Only providing money or monetary support is not enough.
Adoption numbers, meanwhile, are nowhere close to covering these figures. Data from the Central Adoption Resource Authority shows that total adoptions have not risen above 5,000 a year for over a decade and have even slipped a little in the last few years. Some of this is being attributed to improved in vitro fertilization technology, societal pressure that emphasizes biological children over adoption, and a pickup in avenues like surrogacy. Then there are people who are disheartened by the long process or those who fall for schemes that promise to circumvent the process. And these deny thousands of children a happy home. In Mumbai, with Jasilia K., Arundhati Ramanan.
Now, I would like to welcome Mr. Amit sir, who is an advocate at Supreme Court. Sir, we are eager to hear your thoughts on today's topic.
Hello,
Yes, sir.
I'm audible.
Yes, sir. Yes, sir.
Namaskar to all the panelists. We have touched a very relevant topic of adoption today. Adoption, basically, is a worldwide institution. Almost all the religions and the mythologies have some reference to the adoption. Adoption, basically, is an essential. Adoption is basically, a product of historical and evolutionary process. Now, I'll take you to the inside what was before laws before the pre-independent era and what are the laws which have been framed after the post-independence. Now, adoption, it can be legal as well as illegal. Now, if you take the pre-independence era, the adoption was done under the Child Act. The adoption in India long time fall under the ambits and the clutches of the personal law. Since there was no uniform legal law, so before independence, the adoption was done as to the abundant child or to the abundant child under the provisions of the Children's Act 1920. For the first time, the Hindu Adoption and Maintenance Act 1956 was passed by the Government of India. Adoption before that was fall under the long time under the ambits of the personal law, as there was no uniform law. So Hindu Adoption and Maintenance Act 1956 was promulgated by the Government of India. Now, in a country like India, there are various challenges to the adoption. The reason being India being an overpopulated country, and due to lack of education, lack of ignorance, people not aware of the laws, how to adopt a child. It's basically a procedural compliance which requires to be done. Adoption is a legal act of permanently placing a child with a parent or the parents other than the biological parents. The objectives of the adoption are to get an old age protection by the adopted child, to give love and care for all the child and benefit the children's parents, to perpetuate family, name and fame, to keep secure the family property, to secure performance of one's funeral rites, and to preserve the continuance of one's lineage. So adoption, is a product of historical and evolutionary process. Under the personal laws, be it Hindus or Buddhists, Jains, Sikhs, and all, the religions doesn't come up for parlance. So after the promulgation of the Hindu Adoption and Maintenance Act 1956, there are certain provisions been incorporated in the Central Act by which adoption and legal adoptions can be done. So now coming into the background of this act, that what was the position before the pre-independent era and after the post-independent era, adoption under the Indian law. Before independence, there was no provision to adopt an abandoned or orphaned child under the Children's Act 1920. Adoption in India was under long time under the clutches of the personal laws. So after the passing of the act, the provisions given under therein, the legal adoption started. So what is now legal adoption? According to Section 2AA, subclause AA of the Juvenile Justice and Protection of Children Amendment Act 2016, adoption means the process through which the adopted child is permanently separated from his biological parents and becomes a legitimate child of his adopted parents with the rights, privileges, and responsibility that are attached to the relationship. Now, after Section 2A of the Juvenile Justice Protection Act, a central agency laws were framed like CARA, Central Adoption and Resource Authority, under the Ministry of Women and Child Care. But on the one hand, since the acts were passed like the Hindu Adoption Maintenance Act 1956 and the Juvenile Justice Act 2015, but there has been a lot of challenges before the nation, lot of challenges before the country. The major problem being the poverty and the ignorance of the laws, overpopulated country. So there are certain major challenges related to the adoption in India. First is a very lengthy and complex adoption process.
Amit sir, can you turn on your camera, please? We cannot see you.
Oh my goodness, you're not able to see me.
No, your mic is on, but your camera is not on.
Just a minute, just a second.
Yes.
Now?
Yes.
Now it's okay?
Yes. Yes, sir. Yeah.
Well, I just mentioned the background of the pre-independence era and the post-independence era where the acts were formed. Now, in a country like India, which is overpopulated, ignorance of laws, poverty, and all, so certain challenges which the people face. The major challenges related to the adoption in India is being the process is so lengthy and complex in adopting a child. Illegal and unregulated practices are there. Thirdly, returning the children after the adoption, huge gapping in between unregistered children, disability and adoption, LGBTQ and parenthood and reproductive ministry. So there's certain problems which the people face because it's not a very educated country. People who are aware of the laws can approach people who are aware of laws or who can hire the advocates. They go for the valid adoption. Otherwise, the people who are below the vicious circle of poverty or are not educated, they are not aware of the laws. So CARA and these things, agency was formed and this were done. And pursuant to that, the adoption became easy since the authorities was promulgated with the act and all. So further, after the CARA and all agency, this was framed, how the procedures became so easy for the adopting a child. So what was the status of child adoption in India? It is basically a legal and emotional process that involves accepting the responsibility of a caring of a child who is not biologically related to the adoptive parents. Now, after the CARA, a nodal body which was framed for adoption of Indian children and is mandated to the monitor and regulate in-country adoptions. CARA is also designated as a central authority to deal with the inter-country adoptions in accordance with the provisions of the Hague Convention, as Dr. Sumitra Singh initially pointed out and mentioned, in the Hague Convention on the Inter-Country Adoption 1993, ratified by the Government of India in 2003. So, if we see the things in the present scenario, the latest judgments have also been passed by the Honorable Supreme Court and other high courts, which gives you an insight and the latest judgments, in Rajvinder Kaur versus Central Adopted Revenue Authority, the Delhi High Court held that if the adoption of a child is done by HAMA rule, it is not needed to also abide by the rules of the Juvenile Justice Act 2015 to make the adoption illegal. An adoption completed in conformity with the requirements of HAMA would be accepted even in the absence of any outside support. Without recognition from CARA or any government entity, any direct or indirect adoptions done under the HAMA would be exempted from the jurisdiction of the Juvenile Justice Act 2015 and the CARA guidelines of 2017. Further, the court held that it does not mean if the Hindus are governed by Hama, they cannot adopt a child under the Juvenile Justice Act 2015. Section 56, subclause 213 of the JJ Act 2015 allows the enrollment for adoption even to the people who are covered under Hama. Now, in another leading judgment in Shabnam Hashmi versus Union of India in 2014, the Honorable Supreme Court held that the Juvenile Justice Act 2015, which was the act enabling legislation, it aims at achieving the purpose of uniform civil code. Thus, it was held that any person belonging to any religion could adopt a child subject to the rules framed on the point of giving adoption the status of fundamental right. It hesitated but recognized it as a statutory right to adopt. The Ministry of Women and Child Development has recently highlighted the significant backlog of the adoption cases in Maharashtra and in other states, with the highest number of pending litigation adoption cases in India, that was 329 awaiting resolutions. Recently in January 2023, the Bombay High Court directed the state government not to transfer the pending adoption proceedings to district magistrates. Pursuant to the CARA, as also submitted by Dr. Sumitra Singh and other panelists also, Justice Tandon also, that the Ministry of Women and Child Development has introduced the Adoption Regulations 2022, which has streamlined the adoption process. The key changes pursuant to this was that the district magistrates were empowered and the child welfare committees were set up, which were directed to upload the adoption orders and the case status in real time. Since the implementation of the Adoption Regulations 2022, 2,297 adoption orders have been issued by the district magistrates over the nationwide, resolving a significant portion of the pending cases. Now, as I was reading about the insight and the latest judgments relating to the adoptions in India, and recently, Honorable Chief Justice of India, D.Y. Chandrachud Saab, has struck down this. Chief Justice of India, D.Y. Chandrachud ji, while announcing his verdict on a clutch of petitions demanding the legal status to the same marriages, today struck down this CARA, Central Adoption Resource and Authorities CARA, regulation that restricted the queer and unmarried couples from adopting children. The 5-judge bench on this judgment, however, in a 3:2 dissenting verdict, ruled that the non-heterosexual couples cannot be granted rightly to adopt a child. That's a judgment recent one in October 2023. Now, in another landmark judgment in M. Vanaja versus Sarla Devi, died on 6 March 2020, it was held that the adoption of a child by a Hindu couple is only valid if there is a proof of the ceremony. Not only that you have complied with the provisions of the Hindu Adoption Maintenance Act by going for a valid adoption, the judgment said that you need to have a proof of the ceremony, that how you have placed the child from the biological parents to the adoptive parents. So this verdict was given that mentions that such a ceremony is also important. It is mandatory, and the consent of the wife under a Hindu Adoption Maintenance Act, the Supreme Court has ruled. Now, if you take the background of this, in 2011 also, a Supreme Court landmark judgment was passed in Gyasi Lal versus Dhappu Bal, whereby the Honorable Apex Court said that a consent of the wife in any case in any relations is a mandatory for providing adoptions. So I'm very thankful to the Amity University and all the panelists today that this topic is of so much relevance. Like from this all panelist debates, or you can live chat discussions, at least we can provide an insight to all the people in our nation, that besides, if you don't have the knowledge and all, by this channel or this show, you can get to know about the provisions and the judgments which have been passed by the Honorable Supreme Court over the time into time. And I think we have touched a very relevant topic. I congratulate the Amity University, Dr. Sumitra Singh and his team for touching this important topic. Over to you, Dr. Sumitra.
Thank you, sir. You have covered a lot of important issues and challenges related to adoption right in India. Thank you for your contribution to this webinar. Now, I would like to invite Dr. Nitin Sharma, sir, who is Assistant Professor at the Law School, University of Jammu. Sir, please share your valuable insight with us.
Thank you so much, ma'am. Am I audible, ma'am?
Yes, sir, you're audible. And Nitin, sir, it's a pleasure to have you here. Once you were the co-convener and you used to convene the shows. Today we are having you as a panelist. Most welcome. It's your
Thank you so
platform.
much, ma'am, and my sincere thanks to the organizers and especially Amity University, for organizing such a beautiful event. And as Amit Mendirata sir has said, it is an event which is like totally relevant today, and we people need to have such type of discussion so that the commoners and as well as the common populace and the students alike, they can be benefited. And most importantly, the sir has elaborated the Supreme Court, or the, we can say, the child rights jurisprudence in this regard by referring to few cases, and the most recent one that has been decided by Honorable Chief Justice of India. So, at the outset, being a student of international human rights law, I want to start this particular debate or particular discussion from the perspective of the international law. And at the outset, would like to mention this particular fact that uh, first of all, the UN Charter, and then UDHR and the international covenants, especially the International Covenant on Economic, Social, and Cultural Rights, and most importantly, the CRC, the Child Right Convention of 1989. It recognizes the right to adoption, and it always also provides for in-country adoption and always also for inter-country adoption. And moreover, the state parties that recognize or permits the system of adoption shall ensure that the best interest of the child shall be the of paramount consideration. So no doubt international law is always there, and it is of important help to all the persons who are going to be the prospective parents, and for all the childrens who are abandoned, who are orphaned, and who want some sort of care. And for this, the international law is always there, and all the parties who are signatories to the CRC, the Child Right Convention, it is their moral duty and it is their legal obligation to ensure that there must be in place some sort of mechanism, be it in the form of law or in the form of other, we can say, statutory mechanism, or in the form of any commission. Likewise, we have Kara with us, that they must provide for some sort of instrument, some sort of mechanism, so that these children can be adopted and they can be suitably placed in a particular family. So, however, no doubt, as Justice Rajesh Tandon sir has already elaborated, that we have with us Hindu Adoption and Maintenance Act, and even though we have with us a very landmark legislation, the Magna Carta of Child Rights, if I say, that is a Juvenile Justice Act with us. So, the most of the adoptions in India are regulated by this law, and as far as Guardians and Wards Act, so under the Guardians and Wards Act, anybody who is not at or not belonging to the Hindu religion, they can go for they can use this particular legislation, and in that particular act, guardian is appointed, and until the particular child is going to cross a particular age, that is 21 years of age, that person can be taken care of by a particular family. So, however, the adoption is concerned, likewise, our today's topic is challenges related to the adoption process in India. So, as already mentioned by the panelists, that there are near about 31 million children that are orphaned and abandoned as per the UNICEF report. But the data which has been shared by the ministry, it has that only 1.4 lakh children are having single parent, and 10,386 children lost both the parents, and only 492 people are abandoned. So there is a lot of difference between the reporting, and we can say data that has been reported by the ministry and the data that has been shared by the UNICEF or other international bodies. And moreover, there is also a wide gap between adoptable children and prospective parents. And subsequently, it is due to this particular thing that increase the length of the adoption process. Likewise, if we can see the recent data, we can see there are nearly 29,000 prospective parents. They are willing to adopt, but only 2,300 children are available for adoption. So there is a huge gap between the we can say the need and the particular intended parents and the children that are available for adoption. Similarly, there are other issues that are very much related to this problem. And if we can see between 2017 to 2019, the CARA, that is the Central Adoption and Resource Authority, they faced an unusual upsurge in adoptive parents returning children after adoption. Even though after adopting a particular child, there is a new type of mechanism has been evolved, a new type of problem has been arisen, and that is the returning child after adoption. And if we can see, the figures are quite alarming, and according to the data, 60% of all children returned were girls. So in the nation, when we talk about Beti Bachao, Beti Padhao, and there are n number of schemes by the ministries as well as by the commissions, be it NCW and be it other allied bodies, that we need to ensure the best interest of the child and especially girl child. But at the same time, we can see 60% of the children who were returned were girls, and 24 were children with special needs. And we have with us n number of international conventions related to the rights of persons with disabilities, and even in our nation we have n number of laws uh, that can be applied, that can be used for the betterment of the people who are facing any type of disablement. And even though the Prime Minister has categorically termed these people as the Divyang, so 24% of the children who are with special needs, they have been returned. And even though there are few children having age more than 6, they were adopted by a particular family earlier, but they have been returned after some time. So there may be some reasons for this such type of disruption. And if you can see the data, and if we can see if you can analyze this particular pattern, so we came to know that the disabled children and the older children take much longer time to adjust to their adoptive families. So this is the reason that has been given by most of the families as well as most of the social thinkers and the social activists, that these people take much time to become to adjust to their adoptive families. So herein we need to see that the keeping with the challenges to adjust in a particular family, especially in context of older children as well as for in context of the disabled children. So the child welfare committees as well as the other institutions that are responsible for this process, the adoption process, they need to prepare or console children about living with a new family. So here then important aspect about counseling comes into the picture, and it is the prime responsibility of all the stakeholders and especially the child welfare committee that has been already been mentioned by the previous panelists. And moreover, we have with us other bodies, like we have integrated child protection schemes in different states. So they need to make it sure that proper counseling shall be provided to all the children who can be placed or who can be termed as legally free for adoption. And as and when they are properly consulted and they know the particular consequences of the adoption, only then they must be made available for adoption, so that such type of problems shall not arise in the future. Similarly, if we can see there is another issue that is closely related to this problem, and that is the sort of something that closely relate to the materialistic uh, nature of people. And we can say in this particular context, if we can see this particular phenomenon, there is a new phenomenon known as the manufactured orphans and child trafficking. So keeping in view the delay in the adoption process, and as sir has earlier stated that keeping in view the delay in the processes, there is a new amendment has been introduced via in the Juvenile Justice Act in 2021, and there is also some sort of amendment in the adoption rules, wherein the district magistrates and ADMs, additional district magistrates, have been authorized to issue adoption orders. So there is no doubt the law has taken some sort. Law is reformative in nature, and we can say that the concerned authorities, be it ministries and be it other national bodies, they are very keen about this particular process to ensure the best interest of the child. But at the same time, there are other people who are taking benefit of the loopholes that is present in our system. And one of such case is the manufactured orphan and the child trafficking. And I don't want to there is a case study to this effect, and if you can see this in the case in 2018, wherein this Ranchi's Mother Teresa Missionaries of Charity, there was a racket running under the baby selling racket after a nun from the shelter confessed to selling their 4 children. So similar instances are also being seen in other areas also. And even during the pandemic, cases of threat of child trafficking and illegal adoption records comes into play. And moreover, as per the video shared by the organizers of today's discussion, so therein we can see after pandemic this particular process and this particular problem has increased in numerous dimensions. And we can see after pandemic, it has become impossible for us to report each and every bit of information in terms of the child who needs some sort of institutional care, and even though who have been placed successfully in a particular institution, in a particular childcare institution, whether that particular child is abandoned, whether that particular child has having one family, having a single parent, or whether both of their parents are like alive or they are living, and such type of data need to be I think dissected, and it must be reported by the concerned agencies at the outset. And moreover, there are a number of other surveys that has been going on, and as a part of one of the survey, we have also gathered some sort of information relating to the adoption process, and that particular survey has been authorized by the Supreme Court of India. And even though during the course of our survey, we have visited each and every childcare institution, and we have seen there are a number of loopholes, and that was primarily due to the reason people are not at all aware about the child welfare legislation. So this is what Amit Marinjata sir, our earlier panelist, has mentioned in a very good way, that the awareness is the first step towards change, and we need to ensure that all the child welfare legislations need to be presented in one form or the another, and it must be discussed at all levels, be it in academic institutions and be it in other areas of our social, we can say, interaction. And this particular problem after the child trafficking or the manufactured orphans, or we can say this particular problem has been increased manifold after the surge of this COVID pandemic. And one more issue that is closely related to this problem is the issue related to the third gender, although I must not use this word third gender. The reason being, this is also a sort of debate that who is going to the first and the second gender then. So even in this case, like sir has mentioned, the judgment given by the Honorable Court in October 2023, and by way of that, they have recognized by ratio of 3 is to 1, 3 is to 2, they have recognized the right of some groups to legally adopt a child, while at this other time, at the same time, they have not recognized the right of other groups. And they have mentioned it that at this particular point of time, this particular right cannot be given to the people who belong to the LGBTQ community. So, despite the constant evolution of the definition of a family, so the ideal Indian family nucleus still constitutes a husband, a wife, and a daughter and sons. So, keeping view this particular thing, the LGBTQ relationships could not be compared to the Indian family unit concept of a husband, wife, and children. And it has been we have not been yet fully reached to this particular conclusion that this particular right may be given to the LGBTQ community or not. And even though to negotiate these unfavorable legalities, illegal adoptions are becoming increasingly common among queer communities. Also, it has been found through surveys and by way of discussion with the people from uh, the queer communities, as well as from the larger society, that this particular thing has uh, basically augmented the uh, process of adoption in an illegal way. So there is a need to, I think in this direction also, how this particular thing can be mitigated, and how this particular thing can be regulated. So, moreover, provisions under the Surrogacy Regulation Act, as per the video shown by the honorable organizers, it has been suggested that due to the surrogacy and the ART techniques, that like the IVF, so this process has been given some sort of second prominence. So earlier people were like easily we can say forward and go for the adoption process, but due to the after the coming of this intervention of the science and technology in this direction, so we can see that people are firstly they are used to go for the surrogacy, then the assisted reproductive technology, and then they feel like that if there is a need for the adoption, then they come for the adoption. So even though the provisions of this Surrogacy Regulation Bill 2020 and Assisted ART Regulation Bill 2020, both these bills have also completely excluded LGBTQ communities families, and stripping them of their reproductive autonomy. So at the same, so keeping in view the facts and figures in light, and especially the process that has been, if we can see the relevant data in this regard, so the number of adoptions in the country has been on the decline for a decade now. So if we can go by the data from 2010 to 2011, so we can see there were 5,693 cases of the children they were adopted, and coming to the 2020-21, only 400 uh, only 3,142 children were adopted, and the situation in case of inter-country adoption is almost more or less similar. So the number of adoption in the country has been on the decline, and we need to see why this particular thing is happening, keeping in view our approach, keeping in view the sensitivity of the legislation towards this particular vulnerable group, and the legislature is making each and every attempt to place the best interest of the child in the forefront, and it can be easily gauged from the recent amendment that has been mentioned by our earlier panelist, that they have amended even this particular Juvenile Justice Act, and by way of that, if they have given powers to the judicial magistrates and additional magistrates to also promulgate order for the adoption orders. So at the outset, these are the problems, but we need to look. We need to be optimistic, and we need to look beyond these challenges. And so the first thing we can do together is the need to prioritize children welfare. And in this particular regard, I think Kara and the ministry must accord attention to the vulnerable and invisible community of children. They are those who have not been given due prominence, those who have not been given due care in the childcare institutions. And even though there is need to strengthen the institutional mandate, and these mandates must be driven with an attempt, or with the thinking in mind that all the procedures must be child-centric in nature. So child-centric approach is the need of the hour, and we need to sensitize people who are working as a counselor, or who are working as a member in the child welfare committees, and who are in some way or other way associated with child psychology and other related areas. So even though we need to adopt an inclusive approach, and most and I think most notably, and the one of the most important thing, as we can deduce from the statements, and we deduce from the discussion of the previous panelists, there is the process of adoption need to be simplified by taking a close relook at the various regulations guiding the procedure of adoption. And as sir has also stated that there is a lot of debate on this particular aspect also, that there is a need of a uniform law in this aspect. So no doubt, sir, there is a need. We must have a sort of uniform law, but at the same time, what type of legislation we are having now? Even though if we are going to interpret it in the best interest of the child, or with the child-centric approach, even though we can also help our children. And in this particular regard, I want to mention a case titled Shabnam Hashmi versus Union of India. In this case, sir, a Muslim woman has adopted a child, and as we all know that Muslim law doesn't allow such type of adoption, and keeping in view this particular aspect in mind, she filed a petition for recognition of the right to adopt regardless of religion. So in this particular case, the Supreme Court held that the Juvenile Justice Act gave her the right to do so, and noted that the act aims at achieving the purpose of a uniform civil code also. So even in this particular case, if that particular thing is not going to be regulated by any personal law, we can take help from the Juvenile Justice Act, which is secular in nature, and which is the Magna Carta of the child welfare, Magna Carta of the for the child welfare, and the prominent child welfare legislation in country. So with this, I want to close my discussion, and want to listen the viewpoints of other panelists. So thank you so much, Sumitra ma'am, for initiating this dialogue on this very sensitive and very important issue. Thank you, ma'am.
Thank you, sir. And as you know, that once an Amitian is always an Amitian. So it's a pleasure to have you once again on the panel. Thank you so much for
Thank
being
you, ma'am.
here.
Thank you.
Yeah, over to you, Shreya.
Thank you, sir. You have enlightened us with your research and analysis on adoption rights in India. You have highlighted some of the opportunities and best practices in this field. Thank you for your times and efforts. Now, I would like to call upon Srejia, who is a member of ALC, to share her opinions on today's topic.
Thank you, Priyanshu. Good afternoon, everyone. I am Srijaya, and I'll give you a brief about adoption rights and how people in limelight has to go through challenges while adopting children. So, according to Richard Bake, the bond that links your true family is not one of blood, but of respect and joy in each other's life. It is considered by many that for the utmost development and betterment of a child, adoption is the best option. Now, the question arises then why is adoption important? Who does it affect? Well, we don't have answers of it, but biological or not, having children is a wonderful blessing. However, matters of adoption have always invited unwanted questions in the past. Thankfully, the stigma has now lessened down, and we have to thank celebrities for that. While Angelina Jolie and Brad Pitt have won hearts for their rainbow family, Indian celebrities aren't any far behind. If there's one celebrity whose name comes into our mind when we talk about adoption, it has to be Sushmita Sen. The actress was just 25 when she adopted her first child, for which she had to fight a long legal battle. Actress Ravina Tandon's journey has been no less than path-breaking. At a mere age of 21, she took a brave decision of adopting two girls, for which Ravina it was all natural, but for the society it was not. Even our current Chief Justice of India, D.Y. Chandrachud, has two foster daughters, and he has been successful in taking care of them. In India, if we see, there is no family to take care of an orphan child or a child that has been abandoned, and then the government steps in. When any child is abandoned, they are often discarded in an inhuman manner, just like dumped in waste bins or left in bushes or along the roadside. Now, this is a sheer violation of fundamental right to live with human dignity under Article 21 of the Indian Constitution. So, in conclusion, I'd like to say that adoption is a noble cause that gives joy to the children who have been abandoned or orphaned. This also provides an opportunity to shine through the human side of civilization. It's a beneficial program where the child is treated as a natural born child and given all the love, care, and attention. Thank you so much.
Thank you so much, Rijaya. Now, I would like to cordially invite Dr. Vidyotama Jha, who is an advocate at Supreme Court of India. Ma'am, please share your knowledge with us on today's topic.
Almost everything has been said, and I'm left with nothing practically. But I'll try to say something about it because I also think that this is a very important topic, and it is very I feel very connected with the topic, and everything has been said. Still, I would like to say that uh, we have different kind of laws compared to um, any other any like if we see the laws around the world, we have it is very different in India. So the practice of adoption is followed since many decades, but the law for adoption came in the 19th century. So there are various religions in India, but there is no particular adoption law governing the adoption of all religions. Till now in India, there is only one personal law governing adoption, that is Hindu Adoption and Maintenance Act 1956. In India, the religions like Muslims, Christians, Jews, and Parsis do not have their own personal laws governing adoption, because of which they cannot adopt a child and give him or her his family name. They can only become the guardian of the child under Guardians and Wards Act 1890. Hindus, Sikhs, Buddhists, and Jains follow Hindu Adoption and Maintenance Act 1956. The government of India have taken steps to make a uniform law for adoption, but it has not succeeded so far. Sorry. So, according to Hindu mythology, it is believed that only son could be adopted for the continuation of the family lineage and for the performance of one's funeral rites. Even the Dharma Shastras deal only with the qualification of male child to be taken in adoption. Traditionally, a child was adopted for temporal and spiritual purposes, and now adoption is also done to satisfy the emotional and parental instincts of the adopters.
In ancient India, the adoption ceremony, the Tahoma, is the most important witness of the adoption, and it was necessary to invite relatives for the validity of the adoption ceremony. According to Smriti Karas, if a person takes a child as his own, he will be the authority of or heir of the whole property inherited, and the adopted child is still entitled to the property even if a boy is born after his adoption. So traditionally, adoption evolved amongst the Hindus because due to the importance Hindus attached to a male child, every Hindu was enjoined by scriptures to have his own natural child, only failing which he was permitted to have the secondary son. According to the historical events, a natural born child was taken to be the sole representative of a man, and the acceptance of secondary son by adoption was considered completely wrong. Therefore, Hindu scriptures never legitimized any son other than natural born to be begotten by a man. Female adoption was not accorded in early Hindu philosophy. It is evidenced from the fact that the scriptures did not permit the wife or a daughter to perform the funeral rites of a man or utter sacred texts. It was believed that a female child cannot redeem the deceased from hell or save from the suffering of the afterlife. Well, if we see the evolution of adoption in the 19th century, America has a long history of practice of adoption. A legal process of adoption in America creates a status between parent and child where there is no biological relationship between the two. Industrial revolution brought about the most important changes in the human history from 18th to the 19th century. Major changes in agriculture, manufacturing, mining, transport, and technology had a profound effect on the socio-economic and cultural conditions, starting in the United Kingdom and then subsequently spreading throughout Europe, North America, and eventually the world. Due to the Industrial Revolution, modern American adoption law has evolved during the latter half of the 19th century, because of which large numbers of immigrant children who were often in need of care and protection were provided support by Child Welfare Society. These dependent children were sometimes placed in almshouses with the mentally ill and sometimes in foundling homes plagued by high mortality rates. The orphan train movement in America lasted for almost 50 years from 1853 to the early 1900s, and more than 1 lakh children were placed. This social experiment is now known as foster case concept in America. Massachusetts became the first state to pass legislation mandating judicial supervision of adoptions in 1851, and by 1929, all states had passed some type of adoption legislation. During the early part of the 20th century, it was standard practice to conduct adoptions in secret and with records sealed in part to protect the parties involved from the social stigma of illegitimate biological. During the 1950s, many agencies worked to provide children to ease the process of adoption. By the 1970s in America, it was common for parents to wait for 3 to 5 years after their initial application to a private adoption agency before they had a healthy infant placed with them. So children from Europe, Korea, and Japan began to be placed with American families by the adoption agencies after World War II. That time, Korea was the major source of international adoption. The one child policy of the Chinese government has provided a new source of infants to American families. The civil rights movement of the 1960s was accompanied by an increase in the number of transracial adoptions involving black children and white parents. But now transracial adoption account for a small percentage of all adoptions because white families are not able to foster the growth of psychological and cultural identity in black children. Child adoption laws in India. There is no general law of adoption in India to people belonging to different religions. In India, only law related to adoption is governed through the Hindu Adoption and Maintenance Act 1956, which provides to Hindus to adopt a child legally. In India, only Hindus can adopt a child legally, and people belonging to other religions who are desirous of adopting a child can only take the child in guardianship under the provisions of the Guardians and Wards Act 1890. This act is applicable to Christians, Muslims, Parsis, and Jews because their personal law do not recognize complete adoption. Under this act, the relationship which is established after adoption is only of the guardian and ward respectively. Adoption under this act does not confer status of the child on the adopted child. A status of the child on the adopted parent. It is different from the Hindu Adoption and Maintenance Act. The Hindu Adoption and Maintenance Act is applicable to Hindus, Jain, Buddhists, and Sikhs. Under this act, the adoption is irrevocable and it gives full status to the child as natural born to the family. It also gives the right to inherit the property. Only restriction in Hindu Adoption and Maintenance Act is that parents cannot adopt a child of a particular sex if they already have or adoption of child of the same sex. Under the Guardianship Act, when children turn 21 years of age, they no longer remain wards and assume individual identities. They do not have an automatic right of inheritance. Adoptive parents have to leave whatever they wish to bequeath to their children through a will, which can be contested by any blood related child. The aforesaid enactments remain silent about the orphan, abandoned, and surrendered children. There was no codified legislation dealing with the adoption of the children of these categories. As a result, several misconceptions or irregularities appeared in respect of the custody, guardianship, or adoption of these types of children, which were prejudicial to the interest of the children. Then comes the Juvenile Justice Act 2000. This act is applicable to all Indian citizens. It allows adoption of two children of the same sex. It confers status of parents and child and not guardian and ward. It also confers rights available to child on the adopted child. The Juvenile Justice Care and Protection of Children Act 2000 is designed to further care, protection, and development and rehabilitation of juvenile in conflict with law and child in need of care and protection, as well as the adjudication and disposition of certain matters related to them. It is akin to the Special Marriage Act 1954, which enables any person living in India to get married under that act, irrespective of the religion he follows. It provides a uniform legal framework of justice across the country, and this act covers children up to the age of 18 years. Before Juvenile Justice Act, there was no codified legislation. Then comes the Constitution of India. The Constitution of India, the government of India is trying to give full rights and welfare of the children. The Constitution of India provides fundamental rights under Chapter 3. One of these rights is provided under Article 21, which reads as follows: no person shall be deprived of his life or personal liberty except according to procedure established by law. This Article 21 gives every child the right to live with dignity. Article 24 states fundamental rights of the citizens, wherein it is said that it provides the right against exploitation of the children below 14 years of age. Article 44 of the Constitution declares that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. This goal is yet to be fully achieved. Article 39 specifically requires the state to direct its policy to provide healthy environment to the children and to make sure that the facilities are provided. It gives them a sense of freedom and dignity. Youth are protected against exploitation, forced labor, and against moral and material abandonment. Then adoption among different religions in India, there is no general law, as we have seen. And for adoption under Hindu law, the Shastric Hindu law looked at adoption more as a sacramental than secular act. Some judges think that the object of adoption is twofold: to secure one's performance of one's funeral rites and to preserve the continuance of one's lineage. Hindus believe that one who died without having a son would go to hell, and it was only a son who could save the father from going there, or he was called Pooth. So this was one of the reasons to beget a son. Currently, the adoption under Hindu law is governed by Hindu Adoption and Maintenance Act 1956, wherein it extends to only the Hindus, which are defined under Section 2 of the Act, and include any person who is Hindu by religion, including Buddhists, Jains, Sikhs, and to any other person who is not a Muslim, Christian, Parsi, or Jew by religion. It also includes any legitimate or illegitimate child who has been abandoned both by his father and mother, or whose parentage is not known, and who is in neither case brought up as a Hindu, Buddhist, Jain, or Sikh. Prior to this act, only a male could be adopted, but the act makes a provision that a female may also be adopted. This act extends to the whole of India. Then there's Muslim adoption and practice in India. The Mohammedan law are of the view that adoption, such as known to Hindu law, creating a relationship of parentage is unknown to Mohammedan law. They take into account the concept of acknowledgement. The paternity of the child cannot be established by a Muslim if he adopts a child of whom he is not the actual father. According to various authors on Mohammedan law, are of the view that adoption amongst Hindus creates a relationship of parentage, which is unknown to Mohammedan law. The Muslim law does not recognize the validity of any mode of affiliations where the parentage of the person adopted is known to belong to a person other than the adopting father. According to authors like Amir Ali, Wilson, and Abdur Rahim, are also of the view that adoption is unknown to Mohammedan law. They think that the Holy Quran prohibits adoption, but the impression that adoption is not permissible or adoption is not known to Muslim law is totally based on improper application of Sharia law. Before the Sharia Act 1937, adoptions amongst some Muslims were recognized and permissible by customs. But in matters of adoption, Muslim personal law does not automatically apply on a person. So a Muslim never acknowledges another's child as his own, and the child is considered to be the direct descendant by legitimate means. If an adoption takes place, then an adopted child retains his or her own biological family name and does not changes his or her name to match that of the adopted family. In all sense, unlike the Hindus, adoptive parents are not given the status of the natural parents. The Muslim Personal Law Application Act 1937 and its effect on adoption has been that all the Islamic countries have restrictions in child adoption. There are countries like Afghanistan, Bangladesh, Iraq, Israel, and Kuwait who either does not recognize adoption or do not permit the adoption. In Pakistan, adoption is formalized only when a guardian court issues a decree or a guardianship certificate to an individual under the Guardianship and Wards Act 1890. Islam does not recognize adoption. In Muhammad Al-Haddad Khan versus Muhammad Ismail, it was held that there is nothing in the Mohammedan law similar to adoption as recognized in Roman and Hindu system. The Mohammedan law does not recognize adoption as a mode of affiliation. In 1972, the Adoption of Children Bill was introduced in the Parliament in order to make a uniform law of adoption applicable to all the citizens of India, regardless of their religion. However, the bill was withdrawn by the government in 1978 and could not be passed. Shabnam Hashmi versus Union of India. The objection to the concept of adoption in the Muslims under the Muslim personal law as made by Muslim Personal Law Board was that Muslim personal law does not allow adoption, though the kafala system exists for the purpose of welfare of children. As per this system, a Muslim cannot adopt a child, but he can always become a kafil to the child, and he can provide for the maintenance and well-being of the child, which includes a financial support to the child, even though he is not a biological parent to the child. Despite all that, the child will still be considered to be the child of biological parents, and being kafil would not amount to adopting a child. The Honorable Supreme Court held that Juvenile Justice Act 2000, as amended on 2006, is a secular law and applies on all, including the Muslim, and the act has been enacted for the welfare of children, and it enables any person to adopt a child. Thus, a Muslim also, even if he is governed by Muslim personal law, can adopt a child. The existence of the Muslim personal law will not prevent a Muslim to apply under JJA. Thus, a Muslim may oppose to or choose to be governed by Muslim personal law, and hence may not adopt a child, or he may choose to be governed by the Juvenile Justice Act and may therein adopt a child. It was also held that as of today, the right to adopt or to be adopted is not a fundamental right. The reason is that there are conflicting religious views and practices in the matter, and at present, circumstances are not right enough to make it a fundamental right. In yet another case, Manuel Theodore D'Souza and Phillips Alfred Malvin versus YJ Gonzalez and others, the board objects to such a declaration on the grounds already been noticed, namely that Muslim personal law does not recognize adoption, though it does not prohibit a childless couple from taking care and protecting a child with material and emotional support. Adoption, which is provided under Guardianship Act, gives the couple only the right of guardianship, which means that the couple are not the exclusive parents of the child. They are just his or her guardians, and the child can go away and end this guardianship and after he attains the age of 18. Even the child is not secure after attaining the age of 18, because the child will have weaker inheritance rights, and this can be challenged by other children and relatives of the family. The bad part about guardianship is that legally the child reverts to the guardianship of the state in the unfortunate event of the death of the guardians, but in an adoption, the grandparents, uncles, and aunts take care, as happens with any other child. India have many religions, therefore every religion should be governed by different adoption law. but our legislature are not at all giving importance to adoption by non-Hindus. Because of failure on part of our legislature, Muslims and Christians in India are facing emotional and legal problems. They are uncertain about the child as a member of family. Another bad thing of adoption in India is that a Hindu cannot adopt a Muslim child. The Honorable Supreme Court of India saying that it is unlikely that it will be possible to reform the personal laws of the religious minorities, like they have been constantly reformed and changed in the case of Hindu personal law. However, a Muslim may choose to be governed by Muslim personal law and hence may not adopt a child, or he may choose to be governed by the Juvenile Justice Act and may therein adopt a child. So, there is a need of uniform civil code in this regard, since the landmark judgment of Muhammad Ahmad Khan versus Shah Banu Begum, which realizes us that there is the significant need of having uniform civil code in India. All laws except for family law are uniform laws. So there is a need to change this, and one must have same laws for the citizen of India. In case of adoption, there should be a uniform law governing adoption. Just because of religion, children are not adopted. Because of religion, childless parents are not given the full right to adopt a child. They are not legally allowed to call themselves as the parents of the adopted child. Therefore, there is a real need to have uniform civil code with respect to adoption. In this area, the same law is applicable for all citizens in India. Then there would not be a single childless parents. There are three laws that govern, especially govern the laws of adoption, the means of adoption. So they are Hindu Adoption and Maintenance Act, enacted in then the Guardians and Wards Act 1890, and then there is the Juvenile Justice Act. So and there are other major legislations like Central Adoption Resource Authority, which is a statutory entity of the Women and Child Development Ministry that serves as a nodal agency and is responsible for monitoring and regulating in-country and inter-country adoptions. So it regulates adoption of orphaned and surrendered, abandoned children through its affiliated or recognized agencies. In 2021, the adoption regulations came in and it modified the 2017 adoption regulations. The revision was notified in accordance with relevant provisions of the Juvenile Justice Act 2015, and it modifies the adoption regulations 2017. The recently passed Juvenile Justice Amendment Act 2021 aims to tighten and streamline rules for child protection. It specifies that rather than the court, such adoption orders shall be issued by the district magistrate. So, India adopted the United Nations Convention on the rights of the child in 1992 and the Hague Convention on Inter-Country Adoption in 1993 in 2003. So CARA maintains a database of children and registration of prospective parents on a centralized child adoption resource information and guidance system. Then there is a composition that who can adopt. The minimum difference between the kid and either prospective adoptive parent should be 25 years. In the case of related or step parents, adoption age criteria do not apply. Couples with 3 or more children are not considered unless they are adopting children with special needs or who are difficult to place. Apart from resident and non-resident Indians, even overseas citizens of India and foreign parents can adopt children from the country. To adopt a child less than 4 years old, the maximum composite age is 90 in the case of a couple and 45 in the case of a single parent. For adopting a child above 4 years old, the maximum composite age for a couple is 100, while the maximum age for a single parent is 50 years. For adopting a child between 8 and 18 years, the maximum age is 110 and 55 years for a couple and a single PAP respectively. So adoption waiting times have climbed from 1 year to 3 years in the last 5 years because of their own experiences with their original families. Some children even don't want to be adopted. When children are adopted but then return to their birth families, there are complications. There have been reports of widespread fraud and inter-country adoption rackets. As Sir has mentioned about Mother Teresa's missionaries of charity in Ranchi, I won't repeat it. And then there are various panels that have stated that issuing adoption orders by an administrative authority rather than a judicial body is not suitable. There is a need to develop consistent and comprehensive law that is more transparent, responsible, verifiable, less bureaucratic, and applies to everyone, regardless of faith. The new legislation should include protections for the LGBTQ community. The term illegitimate should be avoided in new legislation, and adoptive law should be the same for all children, whether born within or out of the wedlock. And thank you so much for bearing with me.
Thank you, Dr. Vidyutma Jana, for sharing your insightful thoughts on today's topic. This brings us to the end of the webinar. Now, I would like to invite Ms. Isha Kale, who is the head of Satellite Office, to deliver the vote of thanks.
Good afternoon, everyone. I'm very happy and honored to be here today to give the vote of thanks for this webinar on adoption rights in India, challenges and opportunities in a popular nation. This webinar has been very informative and enlightening, and I would like to thank all the speakers, panelists, organizers, and participants for making it a success. I hope you all have enjoyed from this webinar as much I have. I hope this webinar has inspired and motivated you to support and promote adoption in India and to make a positive difference in the lives of children who need a loving and caring family. Here at Amity Legal Aid and Literacy Committee, we try to organize as many insightful webinars we can and also provide free legal aid services to people at our satellite office at gate number 2 of Amity University. We invite you to stay tuned for more upcoming events that will enrich your knowledge and awareness of the legal system and the rights of the citizens. Once again, I thank you all for being part of this webinar. I wish you all a great day ahead. Thank you.
Thank you, Isha. And well, as I said, that Amity is as good as you make it, and wherever you go, your name with Amity will be associated forever. So, thank you everybody for being here. As Amity Legal Aid and Literacy Committee, we are committed to the cause of spreading awareness in the society and the nation. Please join us, as Isha said. Please join us for more of our webinars and stay tuned to Amity Legal Aid and Literacy Committee and also to the website of Amity Law School, Noida. Also, watch out our exclusive radio shows titled Samvidhan exclusively on Radio Amity 107.8 FM. Wishing you all good health and goodbye on behalf of our founder president, Dr. Ashok K. Chauhan sir. Bye bye, everybody. Take care. Maksud sir, let's close the session.